Thank you, Paul. Paul, thanks very much indeed for that. We're still waiting for your ideas on what the collective noun for a group of solicitors is, so please get your answers in. Let's go now to our first plenary session of the day, driving high standards and what the SRA reforms mean for you. Please welcome to the stage our panelists, Richard Collins, Executive Director, Policy and Resources of the SRA, and to speak first, Julie Brannan, Director of Education and Training at the SRA.
Hello, everybody. Well, as you've already heard from Paul, in autumn 2021, we will introduce one of the central planks of our reform programme, that is the Solicitors Qualifying Examination, or SQE. Why are we doing this? Well, first and foremost, it will give us greater confidence in the high professional standards of those who we admit as solicitors. It'll replace the current qualifications, the current courses we require people to take, so it'll replace the LPC, the PSC, and more importantly, it'll replace a system where over 110 individual universities write and mark their own separate exams. With the best will in the world, the good people involved in that process are never going to be able to be sure that their exams are absolutely comparable and absolutely consistent with everybody else's exams. So SQE is absolutely about assuring high professional standards. But more than that, SQE is the key which unlocks the door to greater flexibility of training. In the future, people will be able to choose to qualify through an apprenticeship route, through working as a paralegal, as well as through the traditional routes of a law degree or a non-law degree. One of the great pleasures for me has been going around talking to universities to find out what they're doing to respond to the SQE. And they tell me about plans to integrate SQE training into their law degrees, which at a stroke will take away the cost of the LPC, which can now be as much as £16,700 for the LPC. They're talking about new programs for their non-law graduates who want to qualify as solicitors. And they also talk about involvement in the apprenticeship program. So lots of new ideas, lots of innovation around new ways to train. But we couldn't have done that. We couldn't have permitted that range of training without the SQE, because what the SQE enables us to be sure about is that no matter how people have trained, they demonstrate to us on a consistent basis that they have the legal skills and the legal knowledge to be safe practitioners. So how will the SQE work? Well, in the future, there will be 4 requirements that people will have to demonstrate in order to be admitted as a solicitor. Everyone will have to have a degree or equivalent qualification or experience, and that could, for example, be your apprenticeship or a level 6 SILEX qualification. Everyone will have to pass SQE Stage 1, which will be a test of their legal knowledge, and SQE Stage 2, which will be a test of their legal skills. Everyone will have to complete at least 2 years of work experience in legal services. And as at present, people will have to satisfy our character and suitability test. And for those of you who want to know a little bit more about SQE and about qualifying work experience, I'll be talking at lunchtime about how those will work. So moving on then to what this means for you as law firms and employers. What are the benefits for you? First and foremost, I would say that this gives you information and confidence about consistent standards of those who you are recruiting. So you will have up-to-date, consistent, comparable data about all the candidates who you're thinking about recruiting to your law firm. At the moment, people tell me that what they often do is they look back to A-levels for that consistent, comparable information. SQE will give you up-to-date information, and it'll give you information about people's aptitude for practice as a solicitor. SQE will also give you information about the quality of training providers. We will publish pass rates by provider so you can see which providers do best in terms of preparing their students for the SQE. SQE will give you wider recruitment options. When you're thinking about your future solicitors, you'll be able to think not just about those who come through traditional training contract routes, but also those who train through apprenticeships. You'll be able to look at whether you want to think of a school leaver route into your firm. You'll be able to look at your paralegal, your talent pool there. And it's very interesting when I talk to law firms about apprenticeships. Those who are involved feel very evangelical about it. I was talking to Womble Bond Dickinson at a meeting last week, and they were saying how they put a toe in the water in their offices in the northeast, and they're gradually rolling it out across the country now because they've been so pleased with how it's gone. So for them, the apprenticeship model is great. There may be other firms who say, no, we want to stick to the tried and tested training contract route. And the great benefit of all of this is that it's up to you to choose. This gives you that flexibility about what works best for your business. So this is really about us putting our regulations in the right place. We step back from where it's not needed, and where doing so encourages innovation and flexibility. And we step forward to where it really is needed so that we focus our regulation on high standards. Now, at that point, I'm going to hand over to my colleague Richard Collins.
Thank you, Julie. Good morning, everyone. I'm delighted to be here this morning to talk about the next stage of our reforms and what will be implemented, particularly in 2019. Just reflecting on what Paul said earlier about the changes that we've made over the last 6 to 8 years, this is very much the next stage in that process. Just as with SQE, the primary purpose of the reforms to our standards and regulations is to give a really sharp focus on high professional standards, but making it easier for firms and individuals as trusted legal professionals to deliver services in the way that suits them best and suits clients best, and to enable them to continue to address the continuing problems of lack of access to legal services for members of the public and small businesses in particular. And our goal throughout that is to ensure that solicitors are maintaining the high standards for which they have been well regarded over the years. And I think it's important to emphasise that. Paul talked about those underlying key aspects of being a solicitor: independence, integrity, putting your client's interests at the heart of what you do, supporting the administration of justice and the rule of law. In all that I'm going to talk about in terms of change, it's important to remember that those key hallmarks of a solicitor remain the same, remain unchanged. They've remained in place throughout this reform programme and right back over the decades. Those key hallmarks of a solicitor, the key things that society and we as the regulator expect of you, will remain. In terms of the handbook, you will see our organisational priorities on the slide up behind me. So as Paul said, if you look back 4 years ago to when we started this journey, we knew that we could improve the handbook. At over 600 pages, it was just too long, it was too complex, it was difficult to use and to navigate, and it was also too prescriptive. Lots and lots of detailed rules, micromanaging the way that people did their work. The last big change we made to the handbook, 2010, 2011, was really simply a process of us bringing together a whole series of individual sets of rules which have grown up over decades. And now what we're doing is taking the opportunity to have a more fundamental look at that, rationalise it, and make it simpler and easier for you all to use. It's actually our view that that length, that complexity, the detail was unhelpful. Sometimes people say, well, it's much better that we have incredibly detailed rules so we know exactly what we have to do. Our view is very much the opposite. That complexity, that over-prescription didn't help clarity in terms of people complying with the rules. It just made them too complex, too costly to use, and actually got in the way of firms and individuals providing high-quality services. So in reforming the rules, we've really tried to focus on what matters. Clear high standards, rules that drive good practice, and also protect the public where it's needed. So where have we ended up in that process? Our new standards and regulations are now only about 130 pages long. The rules are not only simpler and shorter, but they are easier to navigate. We've created a much more coherent and simple structure so that people can find what they need when they need it. And we've stripped out rules which we think are over-prescriptive and which don't benefit the public. That gives firms greater flexibility, and we're putting more trust in firms and in individual solicitors to exercise professional judgment to achieve the standards that we've set. And finally, as Paul mentioned earlier, we have decided to mark this change by being clearer, losing the term the handbook, and simply referring to them as our standards and regulations. So when will we be introducing them? Well, earlier this year in November, they passed a significant milestone in that the new standards and regulations were approved by the Legal Services Board. We've got some more work to do before we finalise the implementation date. This conference forms an important part of that process. One of the things we're really interested in hearing from you all today is what more support, information, guidance you would find helpful to help you implement the changes that we'll be bringing in. And then we anticipate the rules coming in probably sometime between April and July next year. But what do they actually mean in practice? I'll talk through at a high level what some of the key changes are. Firstly, as Paul said, there's a very strong focus on the principles. The principles fundamentally about ethical behaviour, about personal standards that we expect everyone we regulate to meet. If in doubt about what you should do in a given situation, the principles are absolutely the right place to start. As I've said, no regulator ever could prescribe precisely what any individual law firm should do in any given set of circumstances. The attempt to do so has in the past been shown, I think, to be a bit of a fool's errand. What we expect you to do as trusted professionals is to go back to the principles and exercise your own judgment about the right course of action in any particular set of circumstances. There haven't been any major changes to the principles. You will still see those key hallmarks of a profession: independence, integrity, acting in the best interest of the client in the principles. There are no entirely new ones, but we have reduced the number down from 10 to 7. We've got rid of some of the principles that we think sit better in the codes. For instance, the principle about dealing with your regulator and the ombudsman in an open and timely and cooperative manner, we think sits better in the codes than as a core principle, a core hallmark value of the profession. There is still a principle around acting in the best interests of client, but also we didn't feel we needed an additional separate principle around proper standards of service. Again, that's now covered in the codes. One of the most significant structural changes we made is to actually move to having 2 codes. So there is one code for solicitors as individuals and one for firms. Over 25% of the individuals that we regulate work in-house, for example, and yet it was clear that many in-house solicitors found it more difficult to engage with the codes because the code covered a whole set of circumstances that weren't particularly relevant to them as in-house solicitors. And mixing that firm and individual code together in many ways made it unnecessarily complex and confusing. Having separate codes makes it clearer for both firms and individuals to understand what's required of them. And I think one of the most important things to hold on to, particularly in this debate around our new permissions for solicitors to act in freelance roles and in unregulated firms, the individual code for solicitors will apply to every single solicitor in England and Wales. No matter whether you are working in-house, in a law firm, as a freelance solicitor, in an unregulated entity, one thing that binds every solicitor together, provides a common set of standards and expectations, is that individual code for solicitors. The second change we've made is really getting rid of unnecessary rules, ones that seem to us only to add to bureaucracy and provided little in terms of public protection. There are lots of examples, but to give you one, currently any approved role holder has to be reapproved if they change firm or change role. And actually the underlying test for those role holders is pretty much the same regardless. So we decided there was no reason why role holders who've already been approved shouldn't be permitted to move automatically to a new role in a new firm or in a new role within the firm, rather than unnecessarily having to jump through the same hoops again. The third main thing to highlight is that we're committed to providing extra support for you around the new codes. This will include things like guidance, case studies, checklists. We're very much doing this in response to feedback that we've received from you, and we'll focus on some of the grey areas where decision-making may not be clear-cut. And we think this guidance and help will be particularly helpful during the transition phase. It's important to remember, though, that the guidance and the way we produce it will look very, very different to the standards and regulations. We are not trying to introduce additional regulation through the back door in terms of guidance. There will be no new obligation through the guidance. It is very much designed to help individuals and firms think about how best to apply the new requirements within their own firms and within their own practice. We'll be publishing the materials from early next year, certainly ahead of the implementation of the new standards and regulations. And in doing that, it's really important for us that we get help and feedback from all of you and from all the firms and solicitors we regulate. The guidance, the checklists, the worked examples will only really work for us if they're working for you and meet the needs that you have. So it's really important that you tell us and let us know what you find helpful. And finally, it's worth noting that we've removed the old indicative behaviours from the codes. The indicative behaviours really were introduced when we introduced the previous handbook as a way of helping the transition from the old rules-based approach to the principles-based approach. There is certainly a risk that people have seen and would continue to see the indicative behaviours as absolute requirements, and therefore the material that was in the indicative behaviours will largely be moved into guidance and checklists and that sort of material. Moving on to the accounts rules, I think this is a particularly good example of where we have made changes in order to really focus on what matters. And what matters here is keeping clients' money safe. The need for change was clear. With our old account rules, half of firms who held client money were at any point in time or during the course of the year were in breach and needed to submit qualifying accountants' reports. Yet the reality was that in nearly all cases, clients' money was not at risk. Firms had simply not been able throughout the year to follow every single prescriptive step in the accounts rules, and that had put them in breach of the rules rather than put them in a set of circumstances where clients' money was at risk. And as I've said, the core principle of the accounts rules is to keep client money safe, not to demonstrate to us that you can run an accounts department. So we've managed to reduce our accounts rules from more than 40 pages to less than 10. To give an examples of the types of rules we've got rid of, we used to have strict time limits for dealing with monies. Firms had 48 hours to deal and transfer any money for their fees or professional disbursements, 14 days to transfer out of office money legitimately held in client account. We think this was onerous. We've replaced it with a rule that says firms need to deal with money promptly. This is an area where we think it's right to put more trust in your professional judgment. Yet the core protections still remain in place where they're vital to protect client money. Firms still need to return client money as soon as they have no need to keep it. Client accounts should never be used as a banking facility, and we expect firms to carry out good record keeping and reconcile their accounts. They should promptly deal with any differences that emerge on that reconciliation. One of the things that you and others said to us in the early days of these reforms was that the move away from greater prescription might leave the door open for the SRA to use discretion too broadly when considering enforcement. So as part of the development of the rules, we also took forward the development of a much more transparent and open enforcement strategy, which we've published. We want to make clear why and when we will take enforcement action, and what we consider to be serious and what we don't. We've also published all of our internal decision-making guidance. It's important no one should be left second-guessing how they should meet our standards or when we might take action. Beyond a focus on high standards, a lot of what I've covered has been about treating you as trusted professionals, giving you more flexibility on how to run your business, taking away anything that is a burden and not necessary to protect the public. Our new standards and regulations should also be easier to use, not only because they're shorter and clearer, but because they're easier to navigate. For instance, we've consolidated our disciplinary and enforcement rules. In the handbook, they were in various places, and now they're in one clear place and follow a logical and chronological path. There will also be opportunities for you to work differently. Paul mentioned these changes earlier, and there is a breakout session on them later on today, where we will give far more information on the detail and give you greater opportunities to talk to us about those changes. But whether it's a small change as to how you run your accounts on the back of the greater flexibility in the accounts rules, or bigger changes such as how you structure your firm, our standards and regulations should help you develop your business to make it more fit for the future and to better help your clients. In this presentation, I've also focused on how we're trying to make sure we focus on high standards while also making life simpler for you. But of course, we're also here to help the public and make their life easier too. Again, later on today, there is a separate session on the new transparency rules, which is an area particularly focused on making access to legal services easier for clients. Joint research that we've done with the legal ombudsman, who I know are here today in our breakout areas, has shown that clients' main priority is regular communication and also clear information about costs. And research has also shown that most people do want to shop around in the legal sector, but only 1 in 5 actually do. Most people think solicitors are more expensive than they actually are, and most people don't use a solicitor when they have a legal problem. We believe there's a real opportunity here for law firms, the chance to reach new customers, including small businesses, bolster trust in the profession, and grow businesses as well. We know that people don't necessarily want to use the cheaper option. Quality is the priority with price second, but they are struggling to make choices at the moment, and that was particularly emphasised by the Competition and Markets Authority. We hope our changes can make sure that the public has better information on price and service, and that will allow them to make better informed choices. Following that, we believe it will ultimately encourage more people to access the high standards that solicitors offer, and we believe that's good news for you and good news for clients. With that, I'll hand back to Julie to talk briefly about continuing competence. Thank you.
It's now just over 2 years since we introduced our new approach to continuing competence. You'll remember the old days when we used to require people to do a minimum of 16 hours CPD each year. What we now say is people must do the training and development that they need to make sure they stay competent and up to date. At the same time, we published our Statement of Solicitor Competence, which we developed with the input of over 2,000 solicitors and clients to make sure that we identified the core competencies that were needed for practice as a solicitor. Since then, we've been out and about. We've been talking to you about how that has gone, how the new process is bedding down, and we will be shortly doing a formal evaluation of the new approach to continuing competence. But what I hear is that people do value the greater flexibility that the new approach offers. We hear firms doing things like introducing new online training and development systems, things like a chatbot that can help people answer ethical questions within the law firm, and simple things like client reviews, peer reviews, lessons learnt reviews. So a wide range of really good and interesting practice. Very interestingly, what I also hear is that on an individual basis, people can see far more the direct relevance of the training that they are doing, which is helping them perform their job better, and that they can now perform that training or do that training in the ways that suit the individual best. So what that is resulting in is greater investment, greater buy-in, greater enthusiasm on an individual basis for making sure that people remain competent and up to date. So this is another example, if you like, of us stepping back from regulating what we don't need to regulate, moving away from the days when we used to count up hours, when frankly we used to dance on the head of a pin to work out whether training should be included in that 16 hours or whether it shouldn't be included, to focusing on what we should be worried about, which is whether people are competent and safe to practice. Good, thank you.
To you, Richard, as well. Now, time for your questions, ladies and gentlemen, on what is a hot topic. And there are two main ways that you can get involved, either online through the app, and we've already got a few questions coming in already, or you can do so in person. Now, due to the size of this hall, if you want to ask a question, please use one of the microphones which are positioned in the different areas of the auditorium. So there's two at the front there, two just at the back, and two further back there. And if you're in the aisles on the side, we've got a few volunteers with roving microphones to answer so that you can ask your questions as well. So, any questions for Julie and for Richard here on this topic? It's quite difficult to see, actually, so if you could put your hand up if you do have some questions, that would be great. All right, okay. Let's go to a lady over there. If you could head down to the microphone. Hi there. Yes, just there. Hello, hi there. Yeah. All right, okay. Can we get a microphone to this lady here? Yeah, yes, over there. Thank you very much indeed. Thank you. Just at the back there. Thanks very much. If you could tell us your name and where you're from. Thank you.
Thank you. Linda Lee, Radcliffe-Sabrassa's regulatory lawyer. I've got two questions. The first, well, one is an observation. I think the profession would welcome guidance on the new rules, Richard. But what's happened in the past is there have been promises gone up on the website and then the page is never updated for years and years. So can you give us an assurance that you will keep on updating information and guidance, and as advice is given out on the helplines about specific information, that information is also immediately put on the website because other people will also be interested in it. And my second question really is about, for Julie, about education and training. I noticed that the LSB have in their business plan talked about revalidation, and I wondered what the SRA's plans were in that regard.
Okay. So I'll pick up the first. Thank you, Linda. Absolutely, I can give that assurance. I think we have really understood recently the need to ensure that guidance and information we give and decisions we make are available across the market to everyone. So publishing information about waivers, publishing the enforcement strategy, etc., I think has an indication of the renewed commitment that we have to that. The guidance we provide absolutely has to be relevant, up to date, and we need to maintain the frequently asked questions which mirror the advice we're giving on the ethics helpline. So I can absolutely give that guarantee. We will do our best. On occasions, we may well fail, but I think when we do that, I think people need to come and talk to us and tell us, and I know we've got good connections with the Law Society, and we're already engaged in debate with Law Society committees about the form of that guidance and the way we can make it available as widely as possible.
Julie?
Yes, and on the second question about revalidation, we have no plans for across-the-board post-qualification revalidation. We have a small number of post-qualification, post-admission qualifications, so higher rights, police station, and we want to look at those in the coming years to make sure that they are good, robust and rigorous assessments, but no plans for across-the-board revalidation.
Okay. Hopefully, Linda, your questions answered to your satisfaction. Jolly good. Excellent. Thank you for that. Let's go to one of the questions on our app for you guys. This is from Andrew. Does the 2-year work experience replace the training contract, Julie?
Yes. So 2 years qualifying work experience can be any work experience in legal services which helps somebody develop the competencies in the statement of solicitor competence. We will then check that they have attained those competencies through the second stage of the SQE. So that will be what we require, qualifying work experience. A law firm, of course, can continue to employ somebody on a traditional training contract, and a training contract will meet our requirements for qualifying work experience.
A follow-up question as well. How much will the SQE cost?
We've just recently released some information about that, so some indicative price, an indicative price range. We'll be able to publish the spot fees when we have finished the development work around the SQE, but what we're saying is that we expect it to be in a price range, this is for both SQE1 and SQE2, of between £3,000 and £4,500. So that's the price for SQE itself. There will be training costs that people may incur as well as that. But remember the cost savings. So there will no longer be a requirement to pay up to £16,700 for the LPC. There will no longer be a requirement to pay about £1,500 for the PSC. So that's about £18,000 worth of savings, with some new costs which we hope will be substantially lower than the present system.
Okay, so significantly cheaper. I'm loving this app, by the way, ladies and gentlemen, because it's not shy. I've got lots of questions here, unlike you lot sitting around, unable to put your hands up. So I just want to follow up, Richard, with this from Paul. He says, how do you respond to accusations that there are now 2 tiers of solicitors and that consumers get less protection using freelance solicitors?
I assume that's not Paul Phillip who's put that one forward to me.
Probably is, actually.
Personally, I don't buy into the 2-tier. There is 1 tier of solicitors. I emphasised at the beginning there is 1 code of conduct. It's one of the many things that just binds solicitors together to the same regulated standards. There are not 2 tiers of solicitors. There is a single tier of solicitors who we expect and believe will deliver consistently high-quality standards and services to the public. What there is there are a range of choices for clients to make about how they access legal services. Those choices exist today. Clients can choose to go to a firm of solicitors, they can go to a licensed conveyancer, they can go to a Silex-regulated firm, independent barrister, unregulated firm. Unfortunately, many choose not to get any proper advice at all. What we are doing is adding to that range of choice. But we're adding to that range of choice by enabling solicitors who are fantastically trained, regulated, bound by a code of conduct, to go out and deliver services in those different markets. So absolutely, I know it's been suggested, but I just absolutely don't buy into the 2-tier idea.
Okay. This is from Julie, and I'm going to direct this to you, Julie. What documentary evidence would you expect to see in terms of the competence statement?
So I think this is about continuing competence. We don't have particular requirements. We don't specify the particular forms that people need to complete. We do have some forms that people can choose to complete if they want on our website. So there are standard templates where people can, which people can use to record the training that they have done and so on. So no specifying of one particular form or another. I think the key thing is to make sure that you have a system in place where you have identified what it is that you have done, why you have done it, so in other words, why it's relevant for your particular role, and the extent to which that training or development has been effective at ensuring that you maintain your competence. So that's those are the three critical things, I think.
Right, okay. Gentleman at the back there with a question. Hello there.
Hello. My question just really relates to harshness of decisions made by the SRA and the other regulatory bodies like the Solicitors Disciplinary Tribunal. Does the whole regulatory system sometimes lack compassion and balance? In particular, if I could just mention a particular case I read about in the Gazette of a very young solicitor who was involved in giving advice in prisons, and she used her mobile phone to allow her clients in the prison to communicate with her. Not only was she prosecuted by the CPS, which possibly there were grounds, but she was also, I understand, barred from practicing for 3 years. It did seem to be a particular harsh decision, and my question really is, do the regulators balance an element of compassion, looking at the person, looking at the matter in the whole, because you are actually stating that you are giving more freedom to how you regulate the rules and the professional practice.
Yeah, thank you. I think it's important to remember that in terms of greater flexibility, in particular, we are talking about flexibility in terms of ways of practice and vehicles you can use to practice through, and about running the firms. The standards would are pretty much unchanging over a long, long period of time. Those core professional principles about integrity, independence, meeting the requirements of the rule of law, and the administration of justice. And I think we are expected by the public to regulate those areas clearly and firmly, but absolutely with a degree of understanding. If you think about that, we regulate over 150,000 solicitors, we regulate over 10,000 law firms, and the numbers of cases that we take to the Solicitors Disciplinary Tribunal in that context are very, very small. But they are the ones that we believe are absolutely necessary to take in the public interest to maintain public confidence in the standards and behaviour of solicitors. And so we don't take those lightly. They are taken to the SDT, where the SDT is an independent body, makes those final decisions. And as I say, I don't think we take them lightly, but we do take them where we would expect to uphold public confidence. And those will be particularly in the areas of where solicitors act dishonestly, or where solicitors don't act in accordance with the rule of law and the need to uphold trust in the administration of justice. So I would say they do need to be seen in that broader context.
Okay. All right, okay. Yes, okay, I'll take you, and then I'll take the lady at the back there. The gentleman here?
Yes.
Yes, sir.
Mr. Myrie, I think the first question that you asked that started the responses was, if I'm a client and I have a problem with a solicitor, what can I do? And Richard Collins did say, amongst other things, go to the legal ombudsman. I don't know how many people are aware, but if you were to go to the legal ombudsman complaining about a solicitor, I am a solicitor, sorry, it's Laurie Neal from England, Stickland and Neal in Birmingham, and I'm the cult for that practice. But you could wait over a year before that case is actually allocated to an investigator. I think that's a business or a service that's not fit for purpose. I don't know what Mr. Collins knows about it.
Obviously, I don't speak for the legal ombudsman. I think the legal ombudsman is here today in the
I've spoken to them already.
In the breakout area. So,
You're ahead of the game, fella.
I'd suggest that you go ahead and have a conversation with them. And I don't say that just to avoid the question. It's just that I genuinely not keen to comment on the performance of another sort of regulator within the sector when they are here, and you can have a conversation with them directly.
Yes, sorry, go on, sir.
I was just going to make the point, but for example, if the legal ombudsman have to write to you, you're asked to respond, give you full file, get it out of archive within 7 days or 14 days, or they report you to the SRA. That's the sort of double standard that I don't like.
Is the legal ombudsman here in the room?
They're busy doing a restructure and a reorganisation, and you're in a queue, apparently.
I've got to wait a year, apparently, for an answer to that question.
Absolutely, and they've confirmed those time levels to me today. So I'm not saying that you're at fault, I'm just saying that this needs to be flagged up, because the public out there are still told by the website 2 to 4 weeks and it'll all be done. And I think it's pretty serious, actually, if that's not being done.
Okay, well, I mean, as Richard pointed out, it's going to be difficult for him to comment on the legal ombudsman himself, but yeah, clearly not in the room at the moment. The lady at the back, I know you've been standing up for a while, I do apologise. Thank you.
Okay. It's Karen Bailey from Bailey Wright and Co-Solicitors, and I'm the culp for that firm. There's 2 questions I've got, one for each of you. Perhaps starting with Julie, if you could clarify. With the new SQE system, you've suggested that it saves a whole load of money. But isn't it right that people are still going to need the training to get to the stage when they can take the SQE exam? And therefore, there's still going to be a cost involved in that, which may not be much less than what they have to pay now. That's right, isn't it? And then they're going to have to pay for the exam on top.
Yes, so you're quite right. So there'll be the costs of the assessment that we can control, and then there'll be the cost of preparatory training. Now, the cost of preparatory training will vary according to the routes that people take. So I think I mentioned that we know some universities are looking to include SQE training as part of their undergraduate law degree. So that means all the preparation for SQE1, the first stage of the assessment, will be wrapped up in that. You'll take away all the LPC costs. Then candidates may take their qualifying work experience, and that is the best training for SQE2. So that, under that model, actually there'll be very few, if any, additional training costs over and above the cost of the assessment. People may, on the other hand, choose to go to universities where they don't get the SQE training as part of their law degree. And in that case, there may be extra top-up training that they need to prepare themselves for the SQE. From looking at the nearest equivalent of that sort of training course, it's the training that currently is offered for the Qualified Lawyers Transfer Scheme. And those costs are still those comparative costs are still substantially cheaper than the total cost of the LPC. So there'll be a range of choices for people to make. There'll be a range of different price points, and we shall see how the market responds to that and what happens to the price of training. That's something we will absolutely wish to keep under review. We will evaluate it once SQE comes in. But what we certainly do hope, and what I certainly already see happening, is training options being developed which can offer a cheaper overall package, a cheaper overall route to admission as a solicitor.
Okay. And again, linked with that, while you can see that larger firms already have their systems for training staff who wish to qualify, with smaller firms and like firms that do, say, more legally aided work, what support's going to be offered to make sure that their people can get through to the stage where they will pass the SQE? Because you can see, like wealthier firms, those people who work there will find it easier to pass those exams than, say, those who work in other firms that may not have the same level of resources and the same systems?
Sure.
Yeah. So again, the best training for the second stage of the SQE, the skills assessment, is actually your work experience. And what I often think is that the work experience people get in smaller firms can be sometimes better than the work experience in larger firms, because they get a lot of direct client exposure. They get to interview clients, they get to run cases, they get to do their own research, they get to do simple applications in court. Those are absolutely the skills that we will require them to demonstrate in SQE2. So actually the firms may be small, but the type of work that candidates get exposed to during their qualifying work experience can be exactly what we want to assess them on in SQE2.
Thank you. And just a quick question for...
make it quick.
Sorry, yeah, it is
I've
a
got
quick
quite a
one,
few
but
questions
it kind
here.
of leads on. It's about, you say that clients have choices as to where they go, but what do you educate them? What do you do to educate them about the choices? Because people will go somewhere and they don't know the difference. Just a quick example, I had a case where a mother came to me who was about to lose her child, have her child taken into care when it was born. And they'd gone to what they thought was a firm of solicitors, and it wasn't a firm of solicitors. And they paid hundreds, if not thousands of pounds for advice. And if they'd taken that advice from someone who wasn't a practicing solicitor, she would have lost her child. And when I tried to complain on their behalf about the treatment they'd received, there was nobody to complain to, because of course it wasn't governed by the SRA. What do you do to tell clients about the differences in the choices they make and the protection? It's all very well saying they've got choice, but if they don't know what choices they're making, then it doesn't mean an awful lot, does it?
Firstly, I think everyone in this room can do something about information and to help people make choices, and that is provide good information, good, clear information about your own firms. The other things we are doing is we are providing information to the kinds of organisations that people go to when they are struck with these difficulties in life that lead them to want to find a solicitor, so charities, citizens' advice, people like that, because often the first place somebody goes is not to a solicitor or a legal advisor, they go to another agency, so we have good connections with those other agencies. We're pushing information through there. We're developing legal choices and publicising that as a port of call for people to go to for information. Things like the new digital badge, where people will have greater confidence when they go to a regulated solicitor to see what protections they have. But the reason I sort of stopped before I answered is because there isn't an easy answer to this. People generally do not spend time when they aren't facing a problem educating themselves about where to access legal services when they do have a problem. Often for these individuals, legal services is a distressed purchase, and we need to try and find ways to get information out to them and be available at the point where they need it. And therefore, I think one of the biggest things we've done and we can continue to do, and I would ask solicitors to do as well, is to work through those kinds of agencies and charities which are often the front line where people go to when they hit a particular problem, so that it's those agencies can give them good information about where to go for help.
Okay, thank you for your questions. Julie, question here from Susanna. Do the new supervision requirements shift the burden on individuals in respect of continuing competence to firms?
I'm not quite sure that I understand that question, actually. The requirements for individuals are to make sure that they take their own personal responsibility for staying up to date and safe to practice. So they will have to make sure that they do what is necessary to meet that objective, and then declare to us on an annual basis that they have thought about their work, they've thought about their strengths and weaknesses, they've identified where they need to focus their training, and what they need to do to make sure that they are safe to practice. In terms of training contracts and the pre-admission position, then at the moment we require the training principal to sign off that a trainee has met the practice skills standards and should be admitted as a solicitor. What we will do in the new system is that we still require qualifying work experience to be signed off. It'll be signed off by the COLP, where there is a COLP, or by a solicitor in the organisation otherwise. But the solicitor there will be signing off that the candidate has had the opportunity to develop the competences in the competence statement. They won't be signing off that they have met a particular standard. We will check that they have met that standard through SQE2, that's through the second stage of the solicitor's qualifying exam.
All right, following on from that, this is from Karen. What is the SRA's views on having a position of deputy COLP and COFA within a law firm to help cover for the respective COLP and COFA in their roles?
I will need to check what our rules say. I mean, personally, I think it is very helpful if people have a second in command that can be gone to in the organisation if people are off on leave or off sick or something like that. But ultimately, the responsibility continues to remain with the single nominated COLP and COFA. But I think it's good practice to have backup arrangements in place to cover for occasions where the frontline nominated individual isn't available.
All right. Okay. Gentleman at the front here.
Thank you.
Hi there.
I've been a lawyer for 24 years. I'm a partner in a fairly hefty sized law firm and specialising in employment law in my own field. Just to give it some context, we've got about sort of 600 staff, so yeah, fair size. And I've got a new paralegal, and she said to me, we deal with people that are unregulated that compete with us. And who looks out for the interests of the lawyers and the law firms? What's our body that does that? And I said, do you know, I don't know. We're heavily regulated. I'm going to be COFA for my firm come April. And we have a lot of compliance responsibilities, of course, and we've got to protect the public and provide high legal services. But I do think it is a failing that people aren't looking out for law firms generally as an industry. I'm not saying form a union, but at the same time, I do think there should be greater protection for us as a profession against unregulated business. So, for example, in the employment context, so the standard of representation that I see in the tribunal is often absolutely shocking. And I know that in the civil world, there's the issue with Mackenzie's friends. So my question to you is, do you think the SRA should be doing more to look out for us as a profession?
Yeah. I suppose two things. Firstly, Parliament has decided that only certain areas of law and legal services should be reserved. And there was an attempt about 6 or 7 years ago to extend the areas of reserved activities to will writing and probate. And the government decided it didn't want to do that. So I think there is very little chance, pretty much zero, I would say, of government extending the range of reserved activities. So the unregulated sector has been with us, and it will be with us, I believe, forever. And the chances are it will continue to grow in those areas that aren't reserved. What we are doing, we think an important step is to enable solicitors to operate in those firms, and that will, we believe, tend to increase the level of expertise in those firms which employ solicitors. In terms of who looks out for solicitors, we have a dual system. We have the SRA as the regulator, and we have the Law Society, which is the broader professional body, which is particularly concerned with not just representing solicitors. The Law Society has a much wider role in terms of its job in the whole professional sector. But very much the Law Society is the body which is responsible for representing solicitors and for making those kinds of arguments on their behalf. But I think that it's important for the regulator and the professional body to work closely together. Yeah. We have a mutually shared responsibility. We have different areas that we focus on within that, but overall we are looking for a strong, well-regulated, confident profession which can act in the best interest of the public.
All right. So we're going to leave it there. We've come to the end. I do apologise. I know there are a few more questions that I've got here, and a few of you in the audience have more questions as well. But SRA staff are available around the marketplace stands to answer any queries that you've got. And Julie and Richard are going to be around all day. Probably wish you weren't around all day now, but you are around all day. So if you do want to have a private chat with them, you can do that as well. Before we break up for our first bit of coffee and comfort break, I just want to share the poll results with you. What is the collective noun for a group of solicitors? Right. Expertise. An expertise of solicitors. Okay, so next year, when another Clive chairs this gathering, it'll be the Expertise of Solicitors Regulation Authority Conference. So ESRAC, I'm sure I could mix that up and make something incredibly rude as an acronym, but I won't bother. Ladies and gentlemen, bit of a break now, and we'll see you all back here at about 11:25. Many thanks. Thank you.